amount after the assessment has been done, the amount that is available to pay towards credit providers is around 6.1 thousand on a monthly basis. Next slide. So the next slide, it's just a spread on the NCR educational and awareness campaigns that we have held in the previous financial year. I'm not going to go through into numbers, but we felt we should also highlight the districts that NCR have touched on in terms of imparting knowledge and also telling consumers about debt counseling as a debt relief measure that can assist them to rehabilitation. So we have managed to cover all 9 provinces and the various districts as shown in the presentation. We can move to the next slide, the next one. The next one, please. Thank you. So I'm going to go through the challenges high level. There are a number of challenges that we have identified. I mean, since implementation of debt counseling, there's been a lot of operational challenges, and there is a detailed document that we have shared with the DTIC showing the gaps that we have picked up and what we propose as challenges. But we felt we should highlight what we believe are key or core challenges that if they could be looked into, even all the smaller challenges that we have, we feel that they would be mitigated. So the first challenge for us as the NCR is that if you compare the process, debt review, as well as the current registration requirements, we believe that the requirements are not stringent or do not commensurate the level of work, particularly the knowledge and experience that is required for someone to offer debt counseling services. Many consumers go to debt counselors with different financial challenges, others with legal action on this and that. So we believe there's a need to up the level of knowledge and experience required for one to offer debt counseling services. And another challenge that we've picked up, we do register debt counselors in their natural capacity. And some of these debt counselors do qualify to register as debt counselors. However, they struggle to establish practices due to lack of capital. And what we have seen is that some they do register and then they sell their registration credentials to people who have financial capability, and they're doing it for a salary. Now, oftentimes these entities implement processes that are not aligned with the prescripts of the NCA, but we do have matters that we have taken to the tribunal where we have sought to get enforcement action on these entities. So we believe that if we could look at the registration requirements and amend Regulation 10 that sets out the criteria, we believe that the registration requirements would be strict and would ensure that all these identified operational challenges are addressed. So that's the first challenge that we have. I mean, it cuts across the level of knowledge and looking at the assistance that consumers need. We believe there's a gap there where we can fill and ensure that our debt counselors are capacitated. I did mention the cost that they go through. And as the NCR, we are also looking into measures in which we can expand and make this course an occupational qualification, which will be done perhaps over a longer period with many modules that will capacitate and develop even already registered debt counselors. Next slide. The second biggest challenge that we have is the misleading advertisements and marketing practices that we have seen. We have seen debt counselors, entities being creative to try and lure consumers into debt review without explaining exactly what the process is. They use words such as it's a payment holiday, and we know that's not a payment holiday. They say up to 50% reduction. You cannot preempt how much the reduction would be without doing an assessment. Others are saying it's a savings mechanism, consolidation. Now, when you say consolidation, consumers think you're going to give them money, a lump sum, and consolidate their debts. So these are the misleading advertisements and marketing practices that we have seen as the NCR. We do have measures in place where when we observe this, we do take enforcement action against debt counselors, and we are currently also finalizing the review of our conditions of registration, which we believe will strengthen our enforcement action to make it a prohibited conduct for debt counselors to advertise their services in this manner. And what is also a concern is a number of companies that are selling leads to the debt counseling industry, and the source of these leads remains unknown. But we have engaged the information regulator, which is the primary regulator that deals with protection of personal information, to find a solution to this growing challenge. And we had a meeting with the regulator in the last month, and they did confirm that investigations are underway. We referred a number of these entities to the information regulator, and we also issued a stern warning to the industry as the NCR in terms of what our positions are. And if you look at the debt review process, which is really a voluntary process, a consumer needs to say, I am heavily burdened by my finances, I need help. So what this list does, they perpetuate this cold calling using call center agents. And these agents, because they are running a business, they are given targets to get consumers to sign up for debt counseling because they are being paid on commission. And we believe that this practice is the one that perpetuates the misleading marketing practices. Next slide. Although there are mechanisms in place currently by the National Credit Regulator, because as and when we observe this either on social media, on the website, or when we do our compliance monitoring activities, we always raise this, and we instruct debt counselors to desist from such practices. We believe that there is a need in the NCA to have this provision that deals with the debt counseling related marketing practices. So we propose that a new regulation be inserted with specifics and limitations on how the advert should have the debt counseling registration number, should have how much are the debt counseling fees, and high level explain what the process is. So we believe that if there could be a provision for this in the NCA, this will go a long way in terms of protecting consumers and strengthening, giving the NCR more enforcement powers to deal with the unscrupulous conduct that we see. But as the NCR, we continue to carry out regular education and awareness campaigns. We issue media releases to bring these practices to the attention of consumers. We have a number of community radio interviews where the attention is really on what consumers need to be aware of and the traps that they need to be aware of so that they do not fall into the traps. Next slide. So, and then the third one talks to the consumer, who is a major stakeholder in the process. When we look at some of the complaints that we receive, we have established that some consumers did not really understand the process and the implication before they signed on the dotted line, because our processes entails doing an investigation, looking at whether the consumer indeed did apply by signing the relevant forms or listening to the recording that the debt counselor has provided. And we have noted that some consumers just signed up without having a proper understanding. And some would come and say, no, I want to exit the process because I didn't understand what it means being under debt review. And as we are aware, the NCA currently does not provide for a mechanism to exit debt review other than when the consumer has paid up their debts. So, and from the misleading advertisements and marketing practices as well that misrepresents debt counseling, this is another reason why many consumers fall into this process. So our proposed solution, just like when you go and apply for credit, you can be given a quotation, be given time to think about before you take the loan. We believe it's important that even for debt counseling, that the NCA provide for an option of a cooling off period for the consumer to really research more, think about it in order to make an informed decision. Although the current application form has disclosures in terms of information that needs to be there, we believe there's also an opportunity to expand on this form with the relevant information that we believe is critical for consumers to know and consume before they sign up for debt review. So we believe that if there could be a cooling off period so that consumers think about this before they sign up, this will go a long way in ensuring and reinforcing that there is understanding of what the process is, what the consequences are, and what their obligations are. Next slide. The next challenge that we have relates to the referral of consented restructuring proposals to the magistrate court or to the National Consumer Tribunal. Here, the challenge that we have picked up is that where the NCA currently doesn't make it compulsory for all consented restructuring proposals to be referred to the National Consumer Tribunal. The Act only makes provision for matters where the consumer is not over-indebted but likely to be struggling, for these matters to only be channeled to the National Consumer Tribunal. So we believe that if you look at what this process is, which is a debt relief measure, and the fact that to refer matters to court would need intervention by attorneys, some debt counselors have found a loop where they collaborate with attorneys and they charge exorbitant legal fees to refer matters to court, even where there's an option of referring matters to the National Consumer Tribunal. Our colleagues have confirmed that to refer these matters to the tribunal is around 577. And on some of these matters, we have noted that debt counselors are charging exorbitant legal fees, 6,000 on average. And they are saying, even on matters where they are referring to the tribunal, they still use their attorneys. And because legal fees are not regulated by the NCR, they say, this is what the attorney has negotiated with me. I do not have power to control how much they can charge. So seeing that this is a debt relief measure, our proposed solution is for the Act to be amended to make it compulsory that all consented restructuring proposals must, and all, we are also referring to the ones where consumers are found over-indebted. So if there is a consent from the credit provider and the debt counselor, we are proposing that the Act be amended to indicate that all these matters must be referred to the National Consumer Tribunal and at a prescribed fee and using a prescribed process to be facilitated by debt counselors only, meaning there's no need for an attorney because the tribunal process, there are pro forma documents that debt counselors can easily use to refer these matters. We believe that this provision will immensely save consumers a lot of legal costs, which are currently being used to refer matters to the magistrate court. But like I say, even when referring matters to the National Consumer Tribunals, some debt counselors are charging legal fees because they allege that the attorneys are involved in assisting them in this process and they do not have powers to dictate to attorneys how much they can charge for the legal process that they provide. So we believe this would be a good provision that would really make debt counseling as a viable debt relief measure, and it will save consumers a lot of money. Next slide. The next challenge that we have is the fact that currently debt counseling fees that are charged are not regulated or are not prescribed in the National Credit Act. And the fees have been developed by the NCR in an attempt to try and ensure that consumers are not exploited. So these are charged in a form of they are set out in a form of a guideline. And oftentimes these fees are challenged, or as the NCR, we are challenged in terms of our powers to prescribe the DC fees because they are presented in a form of a guideline and not as regulations. meaning they don't have that binding power. And although our guidelines have been recognized in some courts, we still see that consumers are still being exploited by debt counselors who are charging fees that are outside the guidelines. And once again, they are taking us on in some matters where we have enforced that they should refund consumers. They say we lack the authority to regulate the DC fees. And for this, we are pleading that to strengthen consumer protection and enforcement powers of the NCR, we would like to have the debt cancelling fees issued and published as regulations. And over and above, given this, the NCR, the powers through regulations, we also propose that the NCR be given the authority to prescribe revised fees, after a predetermined period of time, and obviously following due process where the draft fees are issued to stakeholders for comments and a feasibility study is done. So we believe this would ensure that as time goes, after a certain period of time, we are able to review and issue the fees in line with the market at a point in time. The next slide. So this one is a section in the NCA which deals with when a debt counsellor wants to voluntarily cancel registration. We believe there's a gap here because what we have seen is that a number of debt counsellors would complete a form that is required, but would not cater for consumers that they leave that are under debt review. As a result, you'd find many consumers under debt review without an active debt counsellor, because the debt counsellor has voluntarily cancelled their registration. So we believe there's a gap in this section, and to close this gap, if the section can be amended to make it compulsory that before voluntary cancellation, the consumers must be transferred to a new debt counsellor prior to finalization of the cancellation process. And we currently in the industry have a form that has been developed over time that facilitates the transfer process. And we are proposing that this form be a prescribed form, because it's not a form that is recognized in the Act, but it's a form that operationally we use in the industry just to harmonize the process. And we also have challenges where some debt counsellors will voluntarily cancel when their matters are pending finalization at the National Consumer Tribunal because of prohibited conduct that we have observed as the NCR. So we believe this section creates a loophole for debt counsellors to come in and go out without really recourse for consumers, because the provisions are inadequate and they create gap for consumers to be left without debt counsellors. And although as the NCR, we always look for other debt counsellors to take over these consumers, but we believe this would be a proactive provision that ensures that consumers are protected first before a debt counsellor decides to voluntarily cancel their registration. Next slide. So the other challenge that we have that we believe also does not make debt cancelling appealing to many consumers is that there is no provision to exit the process other than when you have paid up your short-term debts where there is a home loan. And we have many cases where, consumers' financial circumstances change and improve to a point where they can actually pay all their areas and also be able to pay their monthly original contractual agreements. So these are consumers where they don't pay the debt in full, but they are in a position where they can be able to manage their original contractual agreements. So for this, we believe that there's a need for these consumers to be let back into the economy and not be trapped under debt review, because currently they are trapped under debt review either up until they refer their matter to court for magistrate to say, no, you are no longer over indebted, which is also a costly exercise. So our proposed solution is that in the section that deals with clearance from debt review, there are many provisions or insert subsections dealing with removal of record of debt adjustment, or to address the various scenarios for exiting debt review, which will be over and above through a clearance certificate. So have a section that says, if there's we can factually prove that the consumer indeed, the situation has moved from B to C, the consumer can comfortably pay their original contractual agreements, there is really no need to trap them under debt review. So there could be a provision if the Act is amended. And we believe this will make debt counseling more viable as a debt relief measure, because the intention is really to rehabilitate consumers. Next slide. So in terms of the PDA challenges, what we have seen is that for the NCR, it's a bit of a challenge for us to come up with statistics to say this is the total number of consumers that are making direct payments. We did attempt to get reports from credit providers for us to determine, but the findings cannot be conclusive because we have a lot of credit providers that are registered. So we believe that the provision for consumers to choose either to make through a PDA or making direct payments, it poses a challenge. But what we are doing now on the system that we have developed is that we are enhancing this system so that we can be able to get this information directly from debt counselors. So as and when a consumer applies for debt review, there will be an option where a debt counselor mentions whether the consumer is paying directly or paying through a PDA. And this would also enhance our compliance monitoring processes, because we would be able to request for relevant information based on the information from the system. What is a critical challenge, or what threatens the sustainability of PDAs, is the debit order disputes or reversals by consumers when a PDA has already made payments to credit providers. What usually happens, PDAs have to distribute the funds within 5 business days of receipt. And in terms of the applicable provisions for debit order reversals, consumers have about 40 days to dispute debit orders. So some consumers dispute this after 5 days. What happens is that PDA is out of pocket because many credit providers refuse to refund these payments back to the PDAs. So this then threatens the sustainability of the PDAs, because they do pay debts on behalf of unscrupulous consumers who have seen this as a loophole. And the challenge that we also have that affects the entire process is the structure of the current pricing structure, which is tiered in nature. It poses a challenge, especially when one debt is paid off, because of the cascading calculation method of releasing that money to the other debt. It kind of messes up the distribution, because the fees are currently based on how much is a distributable amount. For example, if there's a payment that is less than 100 Rand, PDAs do not charge a fee on that. If it's from 100 Rand to 200, there's a specific fee that is paid. So if a consumer pays off the debts and the cascading is implemented, it distorts the entire distribution, because then it changes how much is the distribution fee, because it is dependent on how much the distribution amount is. So we believe that if we can look at having maybe a percentage structure that would be consistent throughout the lifespan of the debt review application, this will go a long way in ensuring that the payments are standard and there is no distortion in terms of the payment plan of the consumer. So for this, as the NCR, we did a feasibility study in 2018 with various recommendations proposed to the DTIC to issue regulations so that we can address these challenges. We really do not want to lose PDAs in this process, because we believe their contribution is positive for many consumers, and we would really appeal that these regulations be looked into and issued to address all the identified challenges within the PDA space. Next slide. So in conclusion, we know as the NCR and we recognize that there will always be challenges when you implement the legislation, and it is not always feasible or possible to amend the Act. So as the NCR in prior years, to address operational difficulties, we have established a forum that we call Credit Industry Forum. It comprises of all credit industry associations, and the good thing is that we also have consumer representative bodies in the forum like Black Sash, so that they can be able to see that whatever solution that we come up with, consumers' rights and interests have also been balanced. And with this forum, we have really managed to facilitate negotiation, agreements, and cooperation on a number of credit industry related aspects. And what the forum does is, after researching and checking whether there is no contravention of legislation, it makes advisory recommendation to the NCR, and upon consideration, the NCR will issue whatever paper that has been recommended to the credit industry as a guideline. And to this end, this intervention has really brought uniformity in the credit industry. And just to give an example of the challenge that I talked on regarding the withdrawal from debt review, we do have guidelines that guides the industry on provisions that can be looked into to exit debt review, even without the amendment to the Act. But we believe amendment to the Act would be a sustainable solution that would ensure that these gaps are closed. So this CIF Credit Industry Forum is a very valuable forum, and the NCR will continue engage in this forum because there will always be challenges even when the Act can be amended. Next slide. So from our side, we believe that debt counseling is a great debt relief measure that has provided rehabilitation to consumers. And given the current challenges, we have a lot of consumers who are hesitant to opt for debt counseling, and some of the gaps or silence on some key areas in the NCA, the full benefits of debt review are not being realized. And in some cases, our compliance monitoring and enforcement actions are hampered or challenging because I did mention that for debt counseling fees, some debt counselors are taking us on to say you don't have powers to impose this provision. And these are the things that in most cases delays finalization of matters where we believe consumers are being prejudiced. And we appeal that urgent consideration to amend the NCA and its regulation is what is required to realize the intended objective of debt counseling and to ensure that it's a viable debt relief option for financially distressed consumers. And as we always do, we will continue to engage the DTIC on these issues and still continue on our consumer initiatives to capacitate, develop, and warn consumers of the traps that they should not fall into. Thank you very much for your time.
Thank you. Sorry, thank you very much, Ms. Lugodi. I think we'll take the presentation from the NCT immediately, and then we have one question and answer session. So can I then hand over to Mr. Bailey, the Executive Chairperson of the NCT?
Thank you very much, Honourable Chair. I'm going to invite Hazel Alwa, who is a full-time member of the Tribunal, to address the committee today. Thank you.
Good morning, Honourable Chairperson and Honourable members. When we start off, I'd like to give you an indication of the passion and drive of this tribunal in ensuring that we empower consumers and we work together on this debt review process. So the passion and drive of this tribunal and the people working for this public entity have always been to protect consumers and the vulnerable and provide speedy redress. This logo of the tribunal was developed at inception, and it has significant value that we bring forward and continue it at this tribunal. Now, the tribunal, you'll see, is a beacon of light on this logo. And what it means is that we are there to guide and help consumers and give them hope through the orders that this tribunal is empowered to make. So the beam at the center is that guiding light to consumers. The bigger and smaller triangles represent the parties before the tribunal and the justice, and to ensure that fairness prevails. Honorable members, this tribunal is not just a place where staff come to work. It's a place where we come to make a difference in the lives of consumers. And this is what I want to share with you as I go through the process of what the tribunal has done during the debt review process and the difference that we have made. With regard to the debt rearrangement agreements, currently the tribunal receives on average 30,000 debt rearrangement agreements. On average, it adjudicates on 7,087 per quarter, and the average turnaround time is around 29 days. The NCT has enhanced and developed a case management system, which I will talk about in more detail, and this allows the tribunal members to adjudicate on 80 cases per day. This system has been marvelous. It has resulted in an exponential increase in efficiencies and cost savings, the details of which I will share with you. Now, during the debt rearrangement process, a debt counselor will assess the consumer's financial obligations, and if the debt counselor makes an assessment that the consumer is over-indebted, then that matter gets referred to the magistrate's court with a recommendation. However, if the consumer is not over-indebted, but is experiencing difficulties meeting their debt obligations, then the debt counselor sends a proposal to all the credit providers. Now, if all the credit providers accept the proposal, then the debt counselor files a debt rearrangement agreement to be confirmed by the tribunal. The debt counselor will negotiate a longer repayment term and better interest rates for consumers. I'd like to share with you on the next slide, which deals with the exponential increase in debt rearrangements over the past 10 years. So we initially started off, when this tribunal first started, with like 24 debt rearrangement agreements. We now see, as I indicated, over 30,000 cases for the year. Honorable members, this increase in the cases was a double-edged sword for the tribunal. On one hand, we were really excited about all these cases that were coming forward to us. And on the other hand, we had to find innovative ways to ensure that we could make the demands placed before us, and that we could ensure that we offer and adjudicate on these cases as quickly as possible. Next slide. So this is how we've achieved greater efficiencies over the years. So in 2008, the tribunal held hearings for every debt rearrangement agreement that was brought to us. We then found that this was not a very feasible approach. And we did research and we looked at the interpretation of Section 138 of the NCA. And we then realized that the matters could be considered in chambers. We didn't have to have a full hearing for a debt rearrangement agreement. And then members were dealing with 8 cases. So we moved from dealing with 1 case that we had to have a hearing on to dealing with 8 cases a day in chambers. Now, 8 cases may seem a little, however, that was all we could deal with because each tribunal member had to type out the entire order with all the credit providers, with the details of what the agreement was between the credit provider and the consumer, and that then had to be issued out to the parties. From 2014 to 2016, there was a significant increase in the number of debt rearrangement agreements filed with the tribunal. And this resulted in a backlog of over 20,000 cases. And I know that I was before the portfolio committee to explain how this tribunal was going to deal with this backlog. And the tribunal put in a plan. We went and we introduced motion courts where we went to the people, we went to the debt counsellors in the various provinces. And we set up the motion courts, the debt counsellors would bring their cases to motion court, the tribunal members would adjudicate on them, and on the same day, the debt counsellor would get their order. However, this process was successful in terms of trying to alleviate some of the backlog. However, each member could only adjudicate on 32 to 40 cases daily. So we still needed to find another innovative way to get rid of the backlog and ensure that cases were dealt with quicker. So during 2019 and 2020, the tribunal introduced an ICT system, which was called the case management system. And this was introduced to enhance the debt rearrangement agreements. And this brought about a change. So there was a change that we had to take the tribunal members through and the filing parties. So we had to help the debt counsellors and the tribunal members to deal with this change management process. We offered training, we ensured that we made things easier, and where there were challenges with the system, the registrar's office liaised with the debt counsellor, ICT liaised with debt counsellors to ensure that they could file their cases on the system. This, honourable members, has resulted in the tribunal eradicating its backlog, and at the moment, the tribunal members are able to finalise 80 cases per day, as opposed to 40 cases that we were dealing with during the motion court. So our efficiency doubled. This was the golden key. Next slide. Now we've seen over the period of time how we've increased our efficiencies. So in 2015, 2016, the turnaround time on adjudicating the debt rearrangement agreement was 71 days. Currently, our turnaround time is 29 days. This means that the turnaround time has therefore improved by 144%. And while we increase our efficiencies, we ensure that we still keep to our very high standard. As indicated, yes, we are now dealing with 80 cases per day, and we've seen an increase in efficiencies, and we've seen an increase in the cost savings. Now, from motion courts to the case management system, the tribunal is always looking for innovative ways to provide redress and to finalize cases as expeditiously as possible. Our strength is in our innovative thinking and digital capabilities. Now, motion courts worked, but it was costly as we had to travel to the various provinces. And now, with the case management system and the system being online, debt counsellors can file their applications online from wherever they are, and tribunal members can adjudicate on cases wherever they are situated across the country. Next slide. This slide just gives you an overall picture of the case management system. So what happens is the debt counsellor will incorporate all the information of the consumer for a debt rearrangement agreement and capture this information on the case management platform. There's also a system that allows for the payment and for an automatic case number to be generated. That then gets filtered to the case management and the registrar's office. They then look at all the cases that are ready for adjudication. The system has great reports to enable us to ensure that as soon as cases are over the 15-day period, we are then able to allocate those cases. So full-time tribunal member then allocates the cases to various tribunal members. The tribunal members adjudicate on a debt rearrangement agreement, and the system then generates the order. The order that the tribunal members used to previously have to type out and could only deal with 8 cases in a day is now done by the system that generates the order, and with a click of the button, that order is then sent off to the parties and they get the order immediately. So just to take you through, the registrar's office has been working, and the ICT unit work very closely with debt counsellors to give them the support that they need to be able to use our system. And I'd like to share this with you. And I saw an email recently from a debt counsellor to the registrar's office saying, "You guys rock." And I thought, you know, that is such exciting news to know that the system is working. And even when it's not working and it becomes a frustration to debt counsellors, that the team can get in there and help them and make changes to the system to ensure that it's more user-friendly and the debt counsellors can access it and use it. So it's beneficial to everybody along the chain of events, from a consumer entering into debt counselling, to a debt counsellor bringing a case to the tribunal, to a tribunal adjudicating and getting it out to the parties involved. Next slide. This graph just shows you how the cases have evolved over time, and it also tells you over a 3-year period how many cases were filed with the tribunal and how many cases were finalized. The graphs do beg the question as to why. You will see the red column talks about how many orders we granted, and you can see in year 2020, 2021, there were more orders granted than what was finalized, than what was received. In order to explain that, what happens is when we move from one financial year to another, we carry over cases that have not been finalized. And in some years, the number of cases that were carried over were higher. This also depends on the timing. So if the cases were filed towards the end of the financial year, they will be carried over. Also, in terms of the rules of the tribunal has to wait for a period of 15 days from the date that the debt rearrangement agreement is filed to ensure that there's no opposition before it can then adjudicate on the case. So there is that 15-day period that we have to wait for. Now, the tribunal prides itself in ensuring that it does not have any backlog on its cases. That's including the debt rearrangement agreements, as well as all the other cases that come through to this tribunal in terms of the National Credit Act and the Consumer Protection Act. And we believe that we are here to serve and fulfill our mandate. It has been important. If you can just move 2 more slides, please. The next one, thank you. No, just one back. Thank you. It is important for the tribunal to realize what is the impact on the lives of consumers? What are our success stories? And how are we making a difference in the lives of consumers? Now, we have found that through the debt review process, when we finalize a debt re-agreement, we see consumers who have sometimes 15 credit agreements, 16, 20, and a lot of them have home loans, they have vehicles. And through confirming a debt rearrangement agreement, consumers have been able to save their homes and their vehicles have not been repossessed. That is a huge financial strain for a consumer to be relieved of. The family lives, consumers' family lives are affected due to the financial stress that they experience. And that is then reduced if we can confirm an order of the tribunal. What we've seen is that in a lot of the debt rearrangement agreements, the debt counsellors have been able to negotiate reduced fees or interest rates, and we see many interest rates have been reduced to 0%. This is to the advantage of the consumer. Now, some trends we've picked up by looking at the debt rearrangement agreements is that there are very young consumers that are entering into debt review, and there may be a need for greater financial literacy. During COVID, due to the online case management system and the ICT infrastructure, the tribunal was able to immediately continue with adjudication on debt review application. There was not a day lost, and we never stopped working. So even during the hard lockdown, consumers were not prejudiced, as we were able to adjudicate on their cases, and the orders were still generated and sent through to consumers, and our cases were finalized. Next slide. This graph just gives you an indication that the tribunal receives cases filed by the regulator against debt counsellors and credit providers. We've seen during the 2022-23 period, as of January 2023, there's been an increase in the number of applications against debt counsellors, and a lot of them have been settlement agreements that we've seen come through, where the debt counsellor then has agreed, there's been a complaint by a consumer about the service that was offered to them, and the debt counsellors have agreed then to settle with the consumer, give them refunds on any of the fees that they charge them. And this has mostly been in cases where the debt counsellor did not timeously make a recommendation to the magistrate's court or bring an order to the tribunal. And in those cases, the debt counsellor agreed to prohibited conduct in the settlement agreement, which is a requirement before the tribunal can confirm an order. And the second issue was that it also allowed for the chairperson to issue a certificate so that the consumer could go to the High Court to claim damages. So that's what we've seen out of the DC application, is that there's been a lot of settlements with the consumer. Next slide. The NCR touched on a lot of the challenges in the debt review process, and the tribunal recognizes and supports the issues and the required amendments that have been put forward by the NCR. What we find is there are many Section 165 applications that are brought to the tribunal. Now, these are applications brought by the consumer where they say they want the order, the debt rearrangement order, to be rescinded. And some of the reasons put forward by the consumers is they say, but our financial circumstances have changed. I may have gotten a better job or something changed in my circumstances, and I'm now able to pay my debt. And I don't want to be under debt review. But as indicated by the NCR as well, unfortunately, the tribunal cannot rescind that order. And what we've been saying, and through our judgments and advising consumers, is that nothing prevents them from paying off that debt earlier so that they can obtain a debt clearance certificate. And it would be to their advantage because a lot of the debt rearrangements have shown that the interest rates have been decreased substantially. Now, Regulation 27 states that a debt counsellor must issue a clearance certificate. And if a debt counsellor fails to do so, then the consumer can lodge a complaint with the NCR. The other issue that emerges is consumers sometimes say to us they don't fully understand the implications of going under debt review. Or they would indicate that they didn't agree to being under debt review. Now, when the tribunal looks at a debt review application, we look at very specific requirements. We look to see that there's a power of attorney to the debt counsellor and that the consumer has signed it. And in this day and age, there's a lot of move towards digital signatures. And even in those cases, the tribunal has requested that the debt counsellors actually file a whole and outline how they obtain the digital signature of the consumer. So we look at that quite closely. And before order is issued, what we've also indicated is we have seen consumers asking that they be taken off the debt review process because they had issued a notice of withdrawal from the process with the debt counsellor, but the debt counsellor had already proceeded with an order from the tribunal. Now, in instances where a consumer has changed their mind, and if the tribunal has not adjudicated and not issued an order, the debt counsellor can still then withdraw the matter from the tribunal. We have dealt with cases where it was more of a timing issue, where the tribunal had already adjudicated on the case, order was issued, and then the consumer came and said no, but they had actually asked the debt counsellor not to proceed with the application. And in those instances, we did then rescind the order on the basis that the order was erroneously sought by the debt counsellor. Now, on issues pertaining to contracts that may not be understood by consumers, there is a section in the legislation, Section 64 of the NCA, that provides for a right to for consumers' right to provide information They have a right to have the information in plain and understandable language. Now, Section 150I of the NCA empowers the tribunal to make an order to give effect to the right of a consumer if that issue arises before the tribunal. Next slide. Thank you. Now, we have seen through the regulator's stats that there are approximately 1,500 registered debt counselors, and yet the tribunal only receives applications from about 198 of the debt counselors. And the tribunal is a more cost-effective route to follow because the application fee is 577 Rand. What we have also found in the intuitive PDA Limited versus NCR matter, that was before the tribunal noted in the judgment that the NCA does not provide clear wording, allowing the NCR to issue binding guidelines in relation to debt counseling fees. So the NCR has also indicated that there would probably be a need for an amendment around this. We have taken a breakdown in terms of quarter 4 of the debt counselors that have filed in the various provinces. And we have found that in the Eastern Cape, 16 applications were received. The Free State 83, Gauteng 216, KZN 5, Northwest 45, Western Cape 4,900, and where no province was indicated, there were 2,752 cases. Now, the tribunal recognizes this. It also recognizes the need of how do we reach out to the rest of the debt counselors to be able to utilize our services. And the tribunal has put together an extensive outreach and education program for this financial year to reach out to the remaining debt counselors to utilize our services. And this, we will find innovative ways to get the message through to the debt counselors through campaigns, advertising our services, meeting with debt counselors, the Debt Counseling Association, providing the training that will be required to use our system. So that is what we envisage in this financial year to ensure that we have more debt counselors that can use our system to the benefit of consumers. Next slide. The tribunal's powers are limited in that the debt counselor can only file a debt rearrangement agreement in instances where all the credit providers have agreed, and only in circumstances where the consumer is not over-indebted. So only where the consumer is likely to experience difficulties in satisfying their financial obligations, under those circumstances, the debt counselor can file. But if a consumer is over-indebted, then the legislation allows for the debt counselor to only file those matters with the magistrate's court. The NCR has put forward a recommended legislative amendment that looks at providing the tribunal with all cases where the debt counselor, instead of going to the magistrate's court, can bring all cases where there's been consent by the credit providers to the tribunal. The tribunal also, while we're looking at how do we enhance our efficiencies, how do we take this tribunal to greater lengths, and looking at bringing in more cases and more debt counselors to bring cases to us, there would be a need then for us to have additional tribunal members. Over the years, the tribunal, with the limited resources that it has and with certain challenges, has always ensured that we will deliver on our mandate, and we will find new ways to deliver and innovative ways to ensure that we do make a difference. And I would like to share this with you. This is something that the chair always says to us. Mr. Bailey says, I'm here to give this tribunal all that I have. And with that commitment, this tribunal is dedicated to take this organization to greater heights. And we look forward to sharing with you our success stories in the quarters that we are required to present. And we invite the honorable tribunal members also to log on to our cases that we do via Teams and to have a feel for the cases that come before us, how we deal with them, to even visit the tribunal and to see the work that we are doing, because this tribunal is dedicated Thank you.
Thank you very much for
So
this
I invite the
invitation.
Sorry, I invite the members of the portfolio committee to come and see what we are doing. I think I made
Yeah,
a mistake.
no, that's fine. We understood it like that. And I was
Thank
just busy
you.
thanking you for the invitation for us to log on, if possible, or even to visit the NCT. Members of the portfolio committee, there we have the presentation from the NCR and the NCT. Can I just take hands for discussion, please? And okay, there is Honorable Thring. You may start, Honorable Thring. Others will join you, I think.
Chair, if I may, before we start, Chair?
Yes,
just to inform you that after the roll call that Mr. Malamatia, Mr. McPherson, Dr. Twani, and Ms. Ronyani joined the platform, Chair. So just for the record.
Okay, just for the record. Thank you so much. Honorable Thring, then Honorable Ronyana, then Honorable McPherson. In that order.
Thank you, Chair. Chair, also let me just firstly appreciate the presentation that was made. I think the challenges, it's a very good mix in terms of what our different entities are actually doing together with the challenges experienced. But maybe two questions and then a comment. The first question would be, can a debt counsellor also be an owner, partner, director, kind of having shares of your PDA? If not, then that's fine. But if yes, surely this would be a clear case of a conflict of interest. My second question is, should all of the cases of debt relief be transferred to the National Consumer Tribunal? Will the NCT be able to handle the caseload? And I noticed that they've also been asking for additional seats, warm seats in chairs to handle caseloads. But should we have all of the cases being transferred to them, will they be able to actually deal with the caseload? And then thirdly, Chair, which is the comment that I said, I think I would support the need for amendments to the Credit Act, particularly where it seeks to protect our citizens who have fallen on hard or difficult times and will get exploited in the process. I believe that there must be some firm recommendations regarding what our debt counsellors are able to charge. And I think that charging 6,000 Rand for a case to go to the tribunal when the tribunal itself charges under 600 Rand is nothing but abuse and extortion. And I also support the need for an exit clause for those whose financial status has changed or improved and are able to pay off their previous debts, but become locked in because of the current status of regulations. Thank you, Chair.
Thank you, Honorable Ronyana.
Thank you very much, Chair. We welcome both presentations. You know, Chair, I just want to ask a question, right? My first concern is this. We now live in a country where we have seen that between 2021 to date, the interest rates have gone extremely high, which means a lot of consumers are going to be literally failing to pay their debt. A person who bought a house which was 1.5 million in 2001, who was paying almost 11,000, today, after the last interest rate that has been raised, will be literally paying almost 5,000 extra towards what they were paying on their bond. Now, that goes with the car, that goes with the credit cards, the overdraft if they have, any loans that they have. The truth is that consumers are now going to be paying more than they were given those debts at the beginning. Because when you were given those debts in the beginning, actually the bank will check that you do qualify and that you were okay to be able to handle those debts. Now, with the interest rates now being what they are and what they've been over the past 2 years, it means a person who was given debt and they were able to afford their lives, they now find themselves no longer being able to afford. So a lot of people are going to end up getting into trouble. And then defaults are going to happen and all those things. But not that they've done it intentionally so, or they went to get extra debt or anything. It's just that the situation we found ourselves in South Africa now has put them to where they were, to where they are. They started good, they were okay, interest rate knocked the hell out of them, and now they find themselves owing more than what they can afford. Which then brings me to these two entities that have presented. Chair, I'm having a serious problem with Experian and TransUnion, because when a person defaults, they end up being put into these. And I heard them saying that if you go through the debt review, blah, 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 or therapy, whatever you call it, you will end up, once everything is fine, you get cleared, you get removed. The problem is that most South Africans who find themselves being blacklisted on Experian and TransUnion, it gets very difficult for them to remove themselves. It becomes a tedious process for ordinary South Africans to remove themselves out of the Experian and the TransUnion, even after those debts have been paid. A lot of South Africans are going to find themselves in Experian and TransUnion, not even for major debts. I'm talking about smaller things like your Edgar's account. You find yourself in the Experian and TransUnion. Smaller things. Black South Africans find themselves in this situation. Again, Chair, we have a situation in this country where you have people who end up getting jobs of PWP, where you end up working for 6 months or something. These are some of the challenges that we face, because you find a person is working for a certain period of time, which is why one of the reasons EFF always calls for a permanent employment than temporary employments that are sometimes glorified. They end up getting into debts. They don't get another job because the contracts have ended. And again, they find themselves on Experian and TransUnion for smaller nyana debts. And that's where I'm having a problem with this, Chair. So I want, if it's possible, for them to explain to me how can we deal with the issues of finding smaller nyana debts, end up blacklisting consumers of this country. If that can be resolved, Chair, I can be very happy. Thank you, Chair.
Thank you. Honorable McPherson.
Thanks very much. So, I mean, the thing about the credit market is it exists obviously in a very regulated environment. And that is so because we want consumers to have access to credit that they can reasonably afford to pay back, and that offers them protection in a regulated market. Because the alternative to that is loan sharks, where interest rates are, they can be whatever they are. In the regulated market, they're capped, fees are capped, and so on. When you start to mess around with the credit market and you increase the risk for defaults or for people to access credit that can't afford it, you increase the cost of credit for low-income consumers who rely on credit to get through each month. That's just the realities of the system. And so we have to be very careful when we make interventions or when we increase the risk profile for lenders to lend money, because someone has to pay for that risk at the end of the day. The lower the risk, the cheaper the credit, the higher the risk, the more expensive the credit. That's how the financial market works. And I'm not convinced that the DTI and the NCR has done really anything to lower the risk in the market, but have sought to continuously create interventions that increase risk and exclude people from the formal credit market. Now, we were told that the amendment bill that this committee passed was, really going to, assist consumers, and deal with over-indebtedness. And I don't think a single one of those regulations and provisions have actually been enacted by the minister, because he himself realized what a threat that Amendment Act was to the credit market. But the big question is why, since 2006, has the department never brought an amendment to the National Credit Act? I mean, what has it been doing since 2006? I mean, it's a complete dereliction of duty that they continuously talk about an amendment, and yet absolutely nothing has been done about it. And the committee, rightly or wrongly in my view, tried to intervene, and actually, to the minister's credit, he saw that intervention was misplaced. But to this date, the committee has done, or the department has done nothing. And I think the department must identify why that is so. What are officials being paid to do if they cannot even bring an amendment act that they've been promising for 10 years, at least since I've been around, to legislation? I'd like an answer to that. But also, the process of debt counseling is actually, in my view, an innovative way to assist people who get into, difficulties, as articulated by my colleague from the EFF. I mean, I think that, we differ in how those interventions work, but debt counseling is not a bad process. But for some reason, the department or the NCR never wants to interact with debt counselors. So, what discussions, what interactions are had with debt counselors on the challenges that they face in trying to assist consumers? When have there been any symposiums? Have there been any discussions? Please, can you just tell me around that? I'd be very, very interested to do so. And also, what is those lenders in the market, what are their obligations of compelling or being compelled lenders in the market, what obligations do they have to tell consumers, their consumers of credit, that they have the option of going under debt counseling, and not just essentially, having their payment terms restructured. And then finally, linked to my first question, by what date can I have a date of when an amendment to the National Credit Act will come before Parliament? Thank you very much, Chair.
Thank you very much, Honourable Malamacha.
Thank you, Chair. Good morning, colleagues. Good morning, everybody. Chairperson, let me take this opportunity to welcome this short and sweet, very comprehensive and informative presentations. I think they were very much helpful that an ordinary person can now understand how he or she is protected and how best can she be helped. I think the department is hard at work. And I want to start by saying, you will understand, Chairperson, that in each and every situation, there's a room for improvement. If maybe for the past 10 years, there was no improvement of some sort, now there are initiatives that they're trying to deal with that decade time of some sort. We really need to join hands, rather politicizing this, because we are representing the poor of the poorest who were previously disadvantaged. That is why they find themselves in this kind of situation. Because had we been equally in this country, we would not be talking about a pool of Black people who are the main culprits of the whole thing that we're dealing with, as compared to their counter citizens who are walking free from debt. Now, Chairperson, we too, we will be very much happy to support the amendment that of the acts which are seeking to assist our masses. We think that is a positive move and we really need to support that. We are doing so solely because the time has arrived for us to do that. Chairperson, the 144% improvement in terms of the turnaround, and we are saying that is an improvement and it should prove, especially on the turnaround time. With not much time, I would like the tribunal to extend their explanation in terms of the good stories that they've indicated here, that during the COVID-19, they did not just look and watch. They have done a lot to ensure that they assist those that were facing the impact of the COVID-19, especially the consumers. The younger ones who were just introduced to the market, who have future, who find themselves to be facing blacklisted for years to come. I will want the tribunal to share with us the good story and how they've taken that. Committee person, the other one will be the first presentation. It's about more of the educational awareness. I will want them to elaborate. They be able to indicate which provinces. My interest is more on the deep rural provinces. If possible, they indicate how many educational awareness programs have they taken, which provinces, and what is it that they've realized it has impacted, and how best can they improve on that. Now, this other one, which is a bit difficult, but the presenter tried to deal with it, the system, it must also say, this person was long blacklisted, he has finished paying. Now, the 3 days come in, what is it that is sent to the consumer within that 3 days to prove that this person is cleared? Because you find a situation, the consumer has to discover when he's looking for other things. After sometimes he has finished paying, that his name is still there and the message says it is your responsibility. Yet there was somebody who was assigned to assist. I will want them to clarify that on that. Otherwise, thank you so much, Chairperson. The presentation we really welcome. Thank you.
Thank you very much. I think the NCR did deal with the provinces and they actually detailed how many educational awareness programs they had in each province, but maybe you were not on the platform then. But I think your question, your rider question to that is what have they discovered from those sessions? I think for me, if I look at the presentation from NCR, there are 8 proposed solutions and many of them are quite specific. It says amend section this, amend section that, So my question to the the department, how the department can respond on what are they saying about all these amendments that are being called for in order to improve the functionality of the NCR and the NCT. Let me hand over first to Ms. Brown and Ms. Gilbert to give responses where necessary. I see there, and then I'll go to the NCR and the NCT. Honorable Monakeli. Honorable
Chair, thank
Member,
you. Okay. Comrade Chair, thank you very much. My hand was actually up much earlier.
oh, sorry, I didn't see it at all. Sorry.
Okay. No, my first question, you have just covered it. I think I wanted also to hear from the DTIC their take on the proposed amendments to the Act and to the regulations. Because in terms of the presentations as made, it looks like the two entities have proposed to the department for these amendments to be implemented, to be effected. And it looks like there is still those interactions, those discussions. And the tone in terms of the presentation is like they're not getting the necessary support or joy from the department in terms of ensuring that indeed these amendments are actually effected. So if we can get a response, and I think you are right, Chair, from the DTIC itself. My second question relates to the debt councillors in terms of debt rearrangements applications. In terms of the second presentation, it looks like there are provinces that are not reflected there in terms of being covered as far as this rearrangement, the rearrangement applications are concerned, in particular Limpopo. Instead, I see Western Cape has got 4,900 applications, and the provinces like Limpopo is 0. I just want to check what is happening. Why is Limpopo not catered for as far as these rearrangement applications are concerned? Or is it because it's 2,752 that are not allocated? That might be for the province. But even then, compared to Western Cape, it looks like these other provinces are not adequately catered for. Can we get a response as to why is the situation as it has been presented? Thank you very much.
Thank you very much, Ms. Brown and Ms. Gilbert.
Thank you, Chairperson, and thank you for the questions from the honorable members. The amendments have been noted, Chairperson, and the department will consider them in looking at the amendments to the legislation. As indicated, the work that has transpired since the minister came to be the executive authority, what he has done is that he has been consulting with some members of the industry, including the regulators as well, to look at what areas can be considered for the amendments, and the department is working on that, Chairperson. Thank you.
Any comments from Ms. Gilbert before I hand over to the two entities?
Thank you, Chair. The comments are supported, and the department is considering the policy proposals to produce a strengthened framework at the end of the process. Thank you, Chair. Chair, sorry, I just would like to bring your attention to the questions in the chat box. Thanks.
Thank you very much for that heads up. Yeah, I think Honorable Mbuyane has indicated that is also a duty whip in I think in one of these mini plenaries. So he's put his questions in the chat box. So let us just add this to the questions. How the NCR intends to educate the the public on the benefits of debt review. And then debt counseling is a major source of employment, perhaps creating thousands of jobs. How many direct and indirect jobs are created as a result of this debt counseling as an industry? And then there's a question on the Credit Act versus the POPI Act. Please clarify the contradictions which emerge around the Act's distribution of information of consumers. Thank you very much. Hand over to the head of, I think it's Ms. Motsokhari of the NCR.
Thank you, Honorable Chair, and thank you, Honorable Members, for those questions. In terms of the issue surrounding, this is an issue that was raised by Honorable Hlonyana, around the fact that you have instances where credit bureaus blacklist consumers, and it takes a long time for these bureaus to remove names of those consumers from their records, even in instances where they've cleared their debt. And I want to say that in instances where we are made aware of that, we are able to deal with the matter and get names of those consumers removed as required by the Act. And it is only if that is brought